Well, good morning, everyone. Good afternoon to those of you joining from Europe. My name is Jay Morgan. I am the Senior Policy Manager at the Representative of German Industry and Trade. We are the Joint Washington Liaison Office of the Federation of German Industries, the BDI, and the German Chamber of Commerce and Industry, the DIHK. Very happy to have you all here this morning for a discussion on the EU AI Act. I'll just get into a brief intro, introduce our speakers, and then we'll jump right into the discussion. So just as background for the discussion today, AI regulation is gathering momentum both in Europe and in the US. The Biden administration recently issued its executive order on AI, and Congress is in the early phases of considering AI legislation. Meanwhile, in the EU, draft AI legislation has entered the trilogue phase of negotiations between the European Parliament, European Council, and the European Commission. So to discuss the EU AI Act and to compare and contrast with US regulatory approaches, we have a great panel of experts here today. So I'm going to start off with Dr. Axel Spiess, an attorney with Morgan Lewis here in DC. Dr. Spiess counsels on international data protection, EU General Data Protection Regulation, international data transfers, compliance, healthcare, technology, licensing, e-discovery, and equity purchases. He's a longtime correspondent and co-publisher of the German Journal of Data Protection and the European Telecoms Journal Multimedia and Law. Dr. Spiess is frequently quoted in the media for his telecommunications and privacy knowledge. So thanks for joining us, Axel. From the DIHK, we have Luisa Witte. She's the Director of Digital Economy, and she previously worked in the German Parliament and for the German Association of Digital Economy and for the Center for Digital Governance. And then joining us from the Federation of German Industries, the BDI, we have Polina Kubiva. She's the Senior Manager in Artificial Intelligence and Autonomous Systems, and her portfolio includes the AI Act, blockchain, Industry 4.0, robotics, among other topics. She's previously worked at Advice Partners, a strategy and communications management consultancy in Berlin. So with that, the way the discussion is going to be structured today, I'm going to let each of our panelists give some opening remarks. Then I will use my moderator's privilege to ask a few questions after the three of them have each had a chance to give some intro remarks on the EU AI Act and their organization's positions on it. And then we will move into an open discussion Q&A with the audience at the end. So with all of that out of the way, Axel, over to you.
Thank you very much, and appreciate the opportunity. I hope you can hear me well. Greetings from Washington, almost around the corner from Jay. So I'm happy to talk about the AI Act and the privilege to say in a few words what that is all about and where it stands, which is a challenge because it's a very complicated piece of legislation. We'll always keep an eye on the executive order of President Biden from October the 30th here, and Jay and I talked about that, and maybe we can chime in and then compare the approaches and so forth. But the European approach is quite different from the executive order. The AI Act comes from a European Commission proposal for a regulation laying down harmonized rules for artificial intelligence from 2021. So it has been around for a while.
I'm just quickly calling because I want.
All right, someone was not on mute. So that legislation has been around for a while. However, it's now has reached the phase of the so-called trilogue. What's the trilogue? The trilogue is a discussion between the three main bodies, which is the European Commission, the Parliament, and the Council, to come up to and resolve the open issues. And it's always has been criticized as shrouded in secrecy because there's a lot of influence from all kinds of players on the trilogue, and we don't really know what it looks like and so forth. And this is the case for the AI Act in particular, and there's some new developments that we can probably discuss during our round here a little bit later. What I wanted to say is, if I compare the approaches here of the US and then the EU, the AI Act is implementing a new regulation that's modeled on EU product safety legislation, and that imposes a detailed sets of technical and organizational requirements on providers and users of AI systems. The idea is that they say, well, we cannot really figure out what AI is about and so forth, so we want to target the users. That approach has been a little bit watered down by the fact that we now have generative AI and foundation models. But the general approach is that they categorize the AI systems into three layers, so to speak. One where the use of the AI would be completely prohibited. Then we have high-risk AI systems that would bear the bulk of obligations, and then we have everything else. And the AI Act would prohibit only some uses of AI systems altogether. And for the others, it would, for the high-risk systems, it would provide a lot of different obligations like data governance, training, testing, validation, conformity of assessment, risk management system, and post-marketing monitoring. So that is what they have in mind. And also what's maybe quite different here from the approach here in the United States is the enforcement. The proposed AI Act includes a complex oversight and enforcement regime. And if someone infringes with the act, that company could incur tough penalties under the regulations, similar to what the GDPR is providing, and in the range up to 6% of global annual turnover, depending on the violation. And the enforcement would probably be executed by national bodies. So that is also a little bit different here. And the last comment I want to make is that the proposed AI Act adopts a risk-based approach. And here, when it comes to the high-risk models, the Parliament has issued its own version of the AI Act, and it proposes introducing specific obligations for foundation models in addition to high-risk AI systems. And the EU Parliament text defines foundation models as AI models that are trained on broad data at scale, designed for the generality or of output, and can be adapted to a wide range of distinctive tasks. So that's pretty broad. And the idea there is that foundation models should be regulated in particular by certain rules. And that is still up in the air, because now the newest development in Brussels is that there is pushback from France and Germany and some parts, in some part also from Italy, against that part of the AI Act, and that also influences the trilogue here. And that would be a fascinating discussion we can have later, whether we should regulate foundation models or what that means, in particular where it stands, and whether that could mean in the end that there will be no compromise and then everything falls apart. Why is it so important that they come to an agreement soon? Well, next year we're going to have EU elections, and you know that there's always one country in charge of EU matters for 6 months, and the so-called presidency. And right now that's Spain, and there's some ambition from Spain that Spain wants that to bring it to a closure, because otherwise it goes to the next country, and that would be Belgium. And we don't know. It will definitely then take some time to move it to the next country, and then the elections are coming up. So if they don't come to an agreement by the end of the year, they are in hot water. So I would say February next year is the final date when they should really come to an agreement. After that, then they have a major issue with the elections. So I leave it there for the time being. That was just a short overview, and we can also talk about sandboxes later. I just want to mention that topic. That is that developers are encouraged to test new technologies for a limited time period together with the regulators before they bring it on the market. And that's a concept that also triggers some discussion in Europe. So I'll leave it there, and thank you for your attention.
Great, thanks, Axel. And Luisa, let's go to you next.
All right, yeah. I try to keep it as not technical as possible, so to keep it up for the discussion later on. So thank you again, Jay, for the invitation to speak today about the AI Act and also to present the position of my organization. It's a pleasure to meet you all, and I'm already excited about the discussion later and to learn more about the American perspective as well. So before diving into the details of the AI Act, recent proposals, but also what popped up during the latest trilogues, I'd first like to give a short view about how German businesses in commerce and the industry look at the opportunities of AI and also the risk right now. That's quite important to know also what are the negotiation mandates right now and how we perceive this regulation in general. So we conducted an annual survey on the state of digitalization in the German economy, and it basically revealed that in 2022, only 14% of the businesses used or integrated AI as a tool of support or for process optimization and so on. However, 23% more would like to apply it in the future. And in combination with the qualitative feedback that we get from our members, you can generally see that there's a willingness to embrace this opportunity of AI. For example, also to generate competitive edge by increasing efficiency in markets where they cannot, for example, cut costs of production. So hence, the bottom line of our findings is that most companies want to utilize this technology, but at the same time, they are quite risk averse, and they look at this regulation right now quite skeptically. And as a consequence, they basically await for a regulation because they want to avoid this transformative cost concerning potential burdens coming from compliance, for example. So yeah, that's the general stage how the economy looks at the situation right now. And another important factor is that, for example, like 90% of German businesses are SMEs. They are the major drivers of innovation, but also typical standard takers. And that means that in the end, the majority of the economy is going to apply AI rather than developing them. And that brings me to the question how we perceive the direction that the current negotiations on the AI Act are currently taking. And the first statement I'd like to make is that even though there are some flaws and inconsistencies right now in the legislative text, some major disputes still to solve, we are strongly pushing right now for the AI Act to be adopted in the legislative period, meaning, as Axel already explained, by the beginning of 2024. So you can imagine that if it's not adopted, it would leave the German economy and also the European in a particular state of uncertainty and also a state of hesitation of what to do. And that has been the bottom line of our position paper that we just freshly drafted. And hopefully it's going to be available in English as well, so you can check on our website. We issued a couple of others in the process, but I would like to focus now on the main aspects of the current debate. And that is first, I like to refer to the general approach. Alex mentioned it already. It's the risk-based approach. And then I'd like to dive into the debate that it's about the foundation models. That's the main, I would say, point of debate right now, and also which makes the negotiations quite hard. So we generally continue to support the risk-based approach as before. And as it has been originally drafted by the European Commission, because it places requirements and obligations on high-risk AI applications only when there's a justification for it and when it's like a valid one. And a positive outcome of the recent trilogues has been that there's a list of high-risk use cases, and that list can be updated by the Commission in the aftermath of the enaction of the actual AI Act. That's going to be through so-called delegated acts, and we welcome in general that these updates are possible and flexible, and that they can that they are tied to certain criteria. So there must be an evidence, and it must be concrete enough. And that's quite an advantage for us, because we also want the AI Act to be an act that lasts for the next 10 years and not only for the next 2. So that's quite a positive remark in the beginning, maybe. Yes, and also another aspect that I like to highlight is that business also get to exclude that AI models can be used for high-risk applications in contractual terms. And that's quite useful when you consider that these discussions right now are also tied to other issues, such as liability and so on. Yes, and the second point I like to make is now on the foundation models and the debate around general purpose in AI that has been also held on an international level by initiatives such as the I'm sorry, the G7 Code of Conduct. So the background is this, that while the Commission drafted a regulation, no such reference has been actually made to foundation models or general purpose AI. And only in the aftermath, the Parliament and the Council came up with their own ideas, basically to fill this gap. And this development is related to ChatGPT, especially also, and also explains basically why the focus has shifted so much on the beginning of the value chain and dragged the whole negotiations also away from this idea, this initial idea of product regulation. So considering now the current negotiation positions, we think it's fair to look at foundation models more specifically. There are specific concerns regarding copyright, liability, disinformation, and so on. But that's what we think in general should be addressed, not so much in the AI Act, but maybe in related regulations. But irrespective of this, it's important that the risk-based approach is further pursued. It means basically that that throughout the text there are no classifications as high risk without evidence and across the board. And that's also why we generally viewed the proposal from the European Parliament quite critically, because it almost posed as many requirements as applications of high risk would have needed to fulfill according to the text. So that's something we considered quite unrealistic. And yes, and so the Council found a bit of a different reaction to this ChatGPT effect. It touched upon the issue not so broadly, so it mainly looked at general purpose AI. And between the lines, you can read that it mainly wanted to target large language models because of the disrupting effect of ChatGPT. So now that all these proposals have been on the table, a new compromise has been formulated by the Spanish presidency, and that's the so-called two-tiered approach. It's intended to impose basic obligations on foundation models, and to adjust it whenever there's a model that is very capable with additional requirements. And in the view of our organizations, in our organization, the approach is not sufficiently matured. That's mainly because these criteria applied to classify whether you are an AI that falls in one or the other category is not clearly differentiated, and we're not coming up fast enough with a sufficient definition about this approach. And our reaction to all of this is basically that we think it's fair to have basic transparency and information obligations posed on AI models. That's mainly because we think that providers of AI and users, especially in the downstream market, must be able to fulfill actually their obligations coming from the AI Act. So it's not necessarily because we're critically looking towards foundation models. We want them to upscale in the German and European market, but we want to make sure that other actors in the value chain are actually able to fulfill their obligations coming from the AI Act. So in that sense, we are actually also looking a bit more different than at this problem than the German government, which is generally proposing a self-regulating mechanism, which in combination with various initiatives such as the G7 Code of Conduct could work in that sense. But we think that's actually not enough, and we would like to have the responsibilities fairly distributed. And in our paper that we're presenting and also will publish in the next days, we take a very much differentiated perspective on this. So we're not going to either of these extremes, and we don't want SMEs and startups to be prevented to scale up or to make innovations, but we also want the AI applications to enter the market, so to be put into use. And why I presented these facts in the beginning is that actually that's equally important to the German, but also to the European economy. And I remember that's something like I like to finish my short presentation on our view, but also how we perceive the AI right now is basically a quote from Brad Smith, the president of Microsoft, saying at a conference that I was 2 weeks ago, is that it's not only about where AI is developed, but it's also where it's put to use. And considering the facts about the German economy, and I think that's quite a valid observation about this, the actual purpose that the AI should follow, and that it should not over-regulate, but it also should not, focus so much on specific actors in the value chain. It should fulfill the goal as it was initially planned as a horizontal regulation. And with this last thought, I'd like to finish. Yes.
Great. Thank you so much, Luisa. And Paulina, now to you.
Thank you. I have to apologize because my throat is a bit sore today. But yeah, thanks for the invite, and thank you, Luisa, and also thank you, Mr. Spies, for the insights. I would just add some points from our review, because I think Luisa gave a really good overview over the situation, how it is, and over the focus points and the most important topics for industry. We as BDI, we also cover a lot of the so-called Mittelstand and hidden champions, but of course we also represent the majority of also big companies, and we have to mitigate all the interests in this matter, and it's not really easy because, of course, like Louisa said, providers and users and deployers of AI systems have really different needs when it comes to regulation. But actually, I'm quite proud because we have managed to work out some positions. And on the one hand, it means that our working groups are working efficiently and are oriented on a compromise. But on the other hand, it also means that the proposals that we see in the AI Act are not really feasible for industry, not really depending on size or on the topic, company matter, or where in the value chain the company is located. So I would add a few points as general remarks to the AI Act, how it has been developed as a product safety regulation, as Louisa said. So this critically pyramid, so that the most applications are not regulated and only a few ones are prohibited, and then you have in the middle a few ones that are high risk and are highly regulated, and you have to do a lot of bureaucratic compliance obligations to fulfill the requirements. We are not sure as industry representatives that this critically pyramid, as the European Commission imagined it to be, actually has these proportions. Because there has also been a study a few months ago by Applied AI that indicated that because definitions are sometimes really unclear, and especially in all nation states different, it remains for a majority or for a big part of the, I think it was 60% of the applications unclear if they are high risk or not. So this is, of course, something we all know. Regulatory securedness is something that is not good for an AI ecosystem to develop. And I mean, we all know that already the majority of AI systems comes from the US and from China. So Europe has a lot to do and a long way to go to stay competitive. And the AI Act, how it was developed, we are afraid it was not helping. Also, another point I want to make is that we have a lot of overlapping and even contradictory with other regulations on the EU level, namely the Data Act, the Cyber Resilience Act. We have the DSA, we have the DMA, and I think there's going to be a Digital Networks Act coming soon as well. And we also have the GDPR, let's not forget about that, and we have sectoral regulation. So, for example, my colleagues from Siemens Health always point out that the AI Act and the MDR, the Medical Devices Regulation, are actually contradictory. So they need to do two sets of standards to fulfill the requirements, which is really expensive for them. But they always point out that for them it's only expensive. But for smaller companies and in medical devices, a lot of companies are middle and small size. It's actually unfeasible, and it would be a threat to their business model, actually. So yeah, having said that, we are on a point where we can't change the whole logic of the regulation. And I think Louisa is right, we do need regulation somehow. And also I think the political capital invested in this regulation is so high that most of the negotiators won't make it happen, that this regulation is not going to be established and to be voted on. But nevertheless, there is some threats, namely coming from Parliament side, that there are some red lines and some compromises not wanting to be met. And right now, this discussion focuses on GPAI and foundation models. So maybe just for everyone, because I don't know if everyone has a technical background or the time to read in the technical details. So just for a smaller insight. So the foundation models are the basic models, and the GDPI is the application. So I mean, of course, on G7 level and also from AI safety perspective, we are talking about these highly capable AI models all the time. But what German government and French government are emphasizing is that it doesn't really make sense to regulate on a foundation model level, because it's not really, you can't really say what you do with a foundation model. So the two-tier approach sounds neat. We know that it sounds good, because it sounds like you would regulate the really, really big providers of foundation models who are actually already making enough money, and you don't really need to save them from overregulation. And it's mostly American companies. So that's something that people in Europe sometimes, and especially the negotiators, like to hear, and Parliament as well, and they can politically sell it quite good during the election period. But it's not possible to find criteria that indicate the risk of a foundation model to something that is ex ante posted somewhere on the technology level. So if there will be criteria, it would be another question. But everything that is being proposed, for example, capacity of computer infrastructure invested, money invested, 45 million users, that's a threshold from the DSA, or downloads, which is an ex post category, we don't really see the connection there to the risk a system is facing, or a model is facing. So we support German and French government in being really on an industry side, but we also see that the public debate may shift a little bit. And we know this weekend there will be publications in the media about German Aleph Alpha. And I don't know if you're aware, this is the biggest German AI startup. And I mean, it's actually the only AI startup that is so big we have in Germany. They got $500 million of funding a few weeks ago, and they are really prominent. And French is also an AI startup. It's called Mistral, and they are both producing large foundation models. So we know that there's going to be publications in the international and German media that that Aleph Alpha has really good connections to German establishment, and Mistral has really good connections to French establishment, and therefore Germany and France are blocking this regulation because their startups, their AI industries are forcing them to do so. So we see it's a difficult point right now in this debate. We want to emphasize that it's not only the startups that have this opinion on the two-tier approach, it's the whole industry. And yeah, the competitiveness of Europe actually depends somehow also on the development of an AI ecosystem, of all their own AI companies. And of course, large language models and foundation models also reflect the diversity of a continent and of the economy. So, for example, the language diversity that Europe has, and therefore it's really important for Europe to be able to develop their own foundation models. And we know we need much more than less regulation for that. We need computer infrastructure. We need, of course, a lot of capital invested, and we know we lack that as well. But overregulation wouldn't make this whole topic easier. That's why we as PDI advocate for less regulation on foundation model and more regulation probably on GPAI level, and also, like Luisa said, that's my last point, on the responsibilities on the value chain that should be discussed and fairly allocated along the value chain. That's how you also make sure that the providers of foundation models do have responsibility within the value chain. Thank you.
Great. Well, thank you so much. That was great from all three of you. I have a couple of questions off of that. I would encourage the audience to start thinking of some questions. Perhaps we'll get to a couple of them here in our discussion. I guess I'll do a potentially dangerous move for a moderator and jump into the discussion a little bit. But I think off of some of the points that Paulina, you and Luisa were making, it seems like in these international statements that we've seen from the G7 Hiroshima process and the Bletchley Declaration, there's as close as you can get to international consensus around adopting a risk-based approach to AI. Though I think once you dig into that, I don't think that there's a common understanding of risk in terms of or a common definition. And so just to take the Biden administration's executive order as a comparison point, the sort of threshold definitions in there, or what it applies to, are very large models. There are some computing power thresholds in there of, it depends on what exactly the model is being applied to, but the thresholds would be something like 10 to the 26th floating point operation. So very few models fall under these definitions. And then in addition to that, in terms of how the US is defining, shall we say, a high risk model, has to do with potential risks to national security, economic security, public health, and safety. And I think, from the European context, Axel, from a lot of your reporting, I know European definitions of risks often involve more of this understanding of personal data as a fundamental right, as a civil right, and risks to that may feature more highly than say a national security concern, or the weighting of difference, or the definitions. And so I know you've all sort of touched on some of these definitions of what makes a high risk model in the various proposals of the EU AI Act, but I guess I would like to just dig a little bit deeper on what are some of the criteria that are driving the discussion, or are likely to be included in a final text in determining what gets into this higher tier of regulation on the European side. So I'll just throw that in for anyone who wants to start off on that among the three of you. But that's sort of my first question.
Well, as we hear, it might actually turn out that the two-tier approach it's not going to survive the next days. So yeah, we would prefer that. But so to give you a little bit of background to this two-tiered approach, it's based on an article by Kai Zenner in OECD from July. So Kai Zenner is the office head of, or the personal assistant of Axel Voss, who is the shadow rapporteur of the AI Act and a German MEP in the EPP. And Axel Voss is a really influential person in this whole regulation. And Kai Zenner is a really influential assistant of a really influential person in this regulation. And he wrote this article in July, considering that this might be somehow a compromise between the council's text and the parliament's idea of quite heavy regulation in Article 28b of general purpose AI and foundation models. So he made this idea, and he oriented a little bit on the DSA, that he tried to target especially the really big foundation models. And yeah, I mean, you already mentioned, I think it's computer capacity invested, it's money invested, it's downloads, or it's also 45 million users as a threshold. But yeah, like our members oppose all of them actually. So a few weeks ago, we don't really know what actually happened, but we know Mr. Todorace was the negotiation leader in the AI Act from the EPP, suddenly began talking about this two-tiered approach again. And then everyone involved remembered, okay, there has been this article in OECD a few months ago that didn't get as much attention actually. And suddenly the Commission also was really in favor of this idea, and I talked to the Commission about that a few weeks ago as well, and they are really sure that you can determine risk and some technical criteria, and they also develop some obligations for model cards to disclosure several information, etc. It's quite vague yet. So maybe, like Luisa said, the idea of a delegating act might be good. So you could actually develop this idea, make more stakeholder consultations, and maybe even find a common ground. But as it is right now, it's not feasible for us. So yeah, actually, I can't tell you even more details because there are no details, in my opinion. But maybe you want to add something.
Well, I can add on to that one of the requirements for high risks system is to have a so-called fundamental rights impact assessment. And I just want to mention that it's Article 28A of the EP mandate. And people who are in the GDPR world know what that means. That doesn't mean any good thing, because that means that you have to document everything. I'll call it the Full Employment Act for AI advisors here. I don't even know whether there are enough advisors out there. And I can assure you that the companies outside of Europe, they were going to have put a lot of efforts into that fundamental right impact assessment. And then the second point I want to make is simply that there is an exit door being discussed for the high-risk system, that some negotiators say, well, if you only provide systems that cannot really be that dangerous to the society, you can certify to us that you've done your risk assessment, and then you're out of it. So the question is whether that will be in the final version there. The issue is, and I need to repeat that, I said that at the beginning, the GDPR already applies, and that already means there is a legal framework out there that companies need to follow right now, and that is quite burdensome already. It has a lot of requirements on what to do with personal data, transparency, the deletion of data, right to be forgotten, and so forth and so forth. So I see a lot of challenges from that front coming, no matter what the AI Act will be doing to us.
Yeah,
Great.
maybe I could.
Yeah.
Real quick, actually, I don't have much to add or criticize or anything. I think, yeah, in general, as Paulina said, I think the two-tiered approach is not fully specified to actually be discussed really on the political level, I guess. And I think it's some kind of a compromise. However, it's also, as you already said, waters down a bit this risk-based approach, and it kind of creates even more obligations for foundation models, even though they might not even be high risk. So that's a bit the thing, I guess. And but I think still that we're like talking about very much extremes, but at the moment, I guess there's not really room for discussion about the middle in between. I think there is still some ideas and positions about general transparency and information requirements that are already there in the AI Act that could, and also other AI developers said would not be that much of a burden to them, to just help other users and providers in the downstream market to actually fulfill their requirements. That's, I think, still something necessary and adequate. And to Axel, of course, like the Article 28, it's posing so many requirements that even the European Parliament probably would not be able to foresee, like, and not only in terms of data protection, but also all kinds of other requirements, such as you should also consider the energy use that you're putting into the training of your data and so on. So there's a lot more value and also European values that are put into this regulation by the European Parliament, which making its position so extreme. But so it's very difficult now to find common ground. And also with regards to the negotiation, it's very exciting to see what comes out of it, because a lot of it's political play. So to raise the stakes of your negotiation mandate, so you'll be able to come out with something you kind of agree to. And yeah, but it needs to be practical. That's the thing. And rather do it practical also in terms of data protection. It's going to be a topic. Maybe it's going to be revised in the next few years, data protection, because the many say that it's even not applicable to the digital world now with the whole training of AI models, which in general we're talking about AI, but what we really need to talk about is also data, the basis of AI. And there also I'd like to throw in some discussion also on open source solutions, which is quite a difference whether we're talking about open source or preparatory models, and many coming from the outside of Europe. So depending on which one we're talking about, data protection and also information matters a lot.
Great. Well, thank you all. And I just have one more question. Then I see Angelica has raised her hand, so we'll bring her into the discussion here in a second. But I think this one, I don't know. In asking it, I feel like I have a sense of what the answer might be. But do you all see the potential for trade irritants from the AI Act in a way similar to DSA, the Digital Services Digital Markets Act, GDPR, in terms of how they've affected commercial relations, especially between the EU and the US?
Well, the European Commission would say no, because we would have a Brussels effect, and then other countries and other frameworks would align with the AI Act, and we would make a blueprint for general regulation, landmark regulation of AI. I'm not really sure about that. I mean, we will have to adopt AI systems no matter what. So I do think that the trade relations will not be as much affected, but what will be at loss will be the speed and the eagerness of the European companies to actually invest in innovation, because they are unsure how to comply with the regulations. And this is, of course, something that's unfortunate for us, but I don't think that the digital economy and the relations themselves will be affected that much. Yeah.
Okay. Well, no other comments on that, then Angelica, floor is yours.
Sure, Keith. Hi, thank you so much, Jay and everybody, for these really great talking points. I was curious, Axel had brought up the assessments, and I'm specifically would like to hear your thoughts on the third-party conformity assessments, because sorry, I should probably introduce myself. I'm Angelica Dortch. I work for SAP. You might know this little tech startup in Europe. So anyway, we're seeing a growing trend in the US at the state level of really seeing third-party AI audits as the silver bullet, and disclosing publicly what those look like. So New York City specifically requires anybody who's using AI to make an HR decision, you must get a third-party assessment. It's very prescriptive in how those bias assessments are done. One of the things that I think is concerning, though, about third-party auditors is that they're not regulated. There's no set ethical standards. There's no body that regulates them, similar to what we see with the big four auditors in the financial services sector. So I'm curious, what is the commission thinking about in terms of leveraging third-party auditors, and what is going to be their guardrails in terms of having access to intellectual property that adversaries may want access to, because this is something we've brought up to New York City, which is there's nothing stopping a foreign adversary from setting up a third-party auditing company and getting access to these solutions and stealing IP. So I just am curious, from a third-party audit perspective, what would be, if this passed tomorrow, how would these auditors be regulated? What are the guardrails for these auditors to make sure that this technology remains not only safe but secure, and it's not stolen from Europe? Thank you.
I think that's a very good point, and I probably think they haven't really figured that out. The auditors must be certified by the regulators, and that brings me to another point. It's still unclear who's going to be the regulator here. There is some on the EU level. There is some movement that the European Data Protection Supervisor says we want to do it, we want to do it, and you have the Data Protection Agency say we're gonna do it, we are the best, and so forth. So they haven't figured that out, and so keep in mind that this huge piece of legislation will not enter into force until 2025 and so forth. They may not even know right now what's going to happen. I mean, look at training, for instance. If you, I was told by an IT expert, it's not really clear that training is always data processing, and that they're not having huge internal databases there where they gobble up millions and trillions of data sets. So all that needs to be figured out. And I'm a little bit amazed that the data protection agencies, they have set up a working group at the level of the European Data Protection Board. They haven't come out with anything, and they are very cautious there. So my concern is if the AI Act doesn't make it, then you see all kinds of national regulators who step to the forefront and say, yeah, okay, we take that over, and we have our ideas here, and we want to regulate it like this and that and this and that. And then they're going to get pushback from their own governments, because the governments are very concerned that they lose momentum here, and their own startups will not make it.
Great. Any other thoughts on that? All right. Great. Well, Angelica, I'll take you off spotlight. And any other questions here from the audience? Now is your chance. If there aren't any, then I will extend the opportunity to our panelists for any final remarks, anything that you want to make sure that you say before the end, any points that you feel like need to be made. I will just extend that opportunity to the three of you as well. So yeah, whoever would like to start, any burning last comments here.
Maybe, well, just to start, I think we will see a lot more of transatlantic cooperation regarding AI regulation, and a lot more engagement by the US, also over the territory of the US, and a lot more economic involvement in AI questions. I mean, the Inflation Reduction Act also has some software components that are concerning for our companies as well. We have this security tests that are proposed. So I think we will work more together in this matter. I don't think it matters if AI Act comes through or not. Anyways, there will be more cooperation on a global and transatlantic level. Just the last thing I want to add is we also closely monitor the debate on the mysterious AI Pact. I don't know if you're familiar with that, but it is an idea by Thierry Breton, and it was raised in TTC. So we think that, especially if they will come through with the AI Act, this will be something that transatlantically one would want on voluntary terms to bring the AI Act into force even before the transitional periods are over. So I think frameworks like this call will be even more relevant in the future, because there will be even more points to compare and to discuss, and maybe to close monitor and have in mind as interesting.
Absolutely. Yeah, Axel?
Yeah.
Oh, sorry.
No, Axel, go
ahead. Whatever. I have two very small short points to make. First, do your GDPR homework. If you forget about me and everything, don't forget that word. Do your GDPR homework, because GDPR applies huge penalties, class actions, regulators, fines. So be very careful what you do, and document. Second point is the AI Act is not the only document here in the room. You know, there is also an AI liability directive and a revised product liability directive. And the revised product liability directive it covers claims by natural persons for products, including software/AI, and has a strict liability in it, no fault. So keep an eye on that one too here, and not only on the AI Act. It's I call it a triumvirate, or whatever the word is, but it really comes into a package of three here. So that is something I want to stress at the end here.
Great, thank you. Yes,
Yeah.
Louisa.
Yeah, no, I really like this. Let's not only talk about the AI Act perspective that you just presented, because I think yeah, it's especially, I mean, for us, we are like dealing every day and following up on the discussion, but it's important also not to lose the bird's eye view on the context. And that's with regard to the relation of the AI Act to other initiatives and also other existing regulations, such as the GDPR and so on. I could go on and go on and go on because it's so much related to many other legislative acts. And I think that's where actually the challenge begins, because businesses are not only facing the AI Act, they are also facing many other regulations. And also in Europe, we have to face the maybe sometimes unbearable thought that who wants still to develop and also use AI in the end if you're facing so much regulation. And I think that's important to consider it also, that we should focus more on the opportunities, on the support of developing AI, and also as Polina already said, that concerns investment, the availability of data and computing power. And we should also focus on these aspects, so on the realistic mechanisms that we can, and also the policymakers can focus on to make this work. And that's, I think, something that's a bit lost in the debate about how to regulate AI, how to find common standards that work in reality. And in that sense, I guess also standardization on an international level will be something that is more coming to be more important, and also that I will need to deal with a lot next year when hopefully the AI Act is through, because yeah, I would wish for that still, even if it's such a complicated and a heavy loaded political issue right now. Thank you.
Great. Well, thank you. Thanks to the three of you for your great presentations and insights today, and thanks to our audience for joining. RGIT exists to make these kinds of connections, so if you have any questions, feel free to reach out to me or to any of my colleagues in follow-up. We'll also make a recording of this webinar available online in case you want to share it with any of your colleagues to show them what they missed today. But appreciate you all making the time today, and look forward to future discussions. All the best.
Thank you very much. Bye-bye.
Thank you. Bye.